Hi, this is Curt and welcome to another edition of Fire Law Roundup.
In New York State, it's funny that this holding just came out, because if you've been watching Curt and I for the last couple of weeks, this is what we've been talking about. We started in Washington State talking about the public duty doctrine and how Washington State just limited that public duty doctrine to only those duties which were stated in statute versus the common law. And I said, well, that's very much similar. And you talked about similar and dissimilar to the special duty rule. So let me just revisit the special duty rule for everybody. And really, this type of case is what Curt and I are trying to deliver to everybody. And the method and how we deliver is we're trying to teach you law, right? And explain to you so you understand in your professional capacities the legal system and defenses and immunities you may or may not have, depending what state you're in. And here's just another good example. So the special duty rule, we could replay last week, frankly, but I'll do it quickly. So let me go back even one. In order to prove that somebody is liable for the injuries which you unintentionally caused to them, these are not intentional injuries, these are unintentional injuries, like I hit you with my car accidentally, or you died in a house fire because I didn't respond quickly enough unintentionally, right? So in order to prove that somebody hurt you unintentionally, called an unintentional tort or unintentional negligence, the plaintiff, the person suing you, has to prove that you owed them a duty, that you breached whatever duty you owed them because you were negligent or you failed to act like an ordinary reasonable firefighter or whatever. And then third, they have to prove that their breach of their duty directly or proximately caused your injury, and fourth, that you have an injury. So what New York State and many other states do, but in New York State's certainly a very well-regarded rule here, the special duty rule, New York State says, listen, before we get to evaluate breach of duty, causation, any of that stuff, and even before we look at whether you even owed a general duty, when it comes to municipal actors performing a municipal service, and generally one that's discretionary, we're going to give a protection, a heightened protection to our municipal actors. And this is always why I tell at least New York firefighters, don't worry so much about losing a lawsuit, right? Don't try to get sued, but don't worry too much, because there's a lot of protections. And one protection is the special duty rule. So here, before you can ever proceed to the, did I breach any duty? Did I cause you any injury? Even if you messed up on scene, the courts say, but a municipal actor, a firefighter, a police officer, must have formed a special relationship with, and I'll give some examples and then we'll compare here, must have formed a special relationship with the injured party. So for example, in a very famous case in New York, a woman calls the police department and says, help, there's somebody in my house. I'm, stuck in a closet and the person's going to kill me and I'm hiding. And the dispatcher says, stay right there. We're coming. And then proceeds to send the person to the wrong address. Now, what then happens is the police go to the address, knock on the door and say, hey, we're here. Nobody's here. Okay. And they just cancel the call. They close the call. They don't confirm the correct address. The problem wasn't that they, in that case, that they went to the wrong house. It's that they never confirmed the right address. And then the person ends up getting stabbed and killed. And in this case, they said, listen, the dispatcher spoke to the person. The victim, ultimate victim, relied on the dispatcher and said, okay, I'll stay right here. And I relied because you told me you're going to do something that I knew if you didn't do, I would suffer harm. And those are very important elements when I discuss this case. So that's what it takes to form a special duty. One-on-one reliance between the person who tells you they're going to do something and the ultimate victim or the person who's injured, justifiable reliance by the victim, right? Who, hey, you told me you're going to send the police. I'm waiting. And I have to rely to my detriment. Okay, now let's compare that, contrast that with this case. Here, there is a fire already well involved. Fire department gets there, right? Chief gets there. All the apparatus aren't coming, and there's an allegation you didn't send enough, you didn't send them timely enough, they didn't get there, right? You're basic, you didn't get out in time, you didn't get to me in time, and had you done so, my house could have been saved. But the fire had already started. An assistant chief gets there and says to the homeowner, hey, relax, you're going to put the fire out, right? Like you would with anybody. We got it, we're coming, we're on the way. And then sues because, well, you didn't get it, you weren't on the way, whatever, and alleges you were negligent. Now, assume for the moment, because I want everyone to understand this rule, assume for the moment that the fire department really screwed up. It wouldn't matter. That's how strong of a protection this is, because the court said you didn't form that one-on-one relationship. But the little bit of different facts in here are interesting. So there's two things the court really looks at. One, the court says is, listen, even though the chief said to the homeowner, we got it, we're on the way, we're going to put the fire out, that conversation didn't cause the homeowner to rely on the chief, right? And all he was doing is reciting the general common law duty, because there's no law that says you will put out the fire, right? So at least in New York. And so all he was doing, says the court, was relaying, yeah, look, we're going to come and we're going to, fight the fire. So that duty, as we talked about, is owed to the public at large. And until I form a one-on-one relationship with you, I don't owe you any duty. And here he said, just telling them what you're going to do isn't enough. Now, that's very different than the police or the dispatcher saying, hey, we're coming to save you, stay where you are. Because the court notes the second part of this. The fire was already going. There was nothing the homeowner was going to do to change his conduct. Now, there is another case you, Curt, are familiar with where the fire department gets there and said, and the husband was trying to go back and rescue the wife.
Yeah, the starter case.
Right, exactly.
Right.
And the fire department says, we will go get the person so the husband doesn't go and get her. Now, frankly, they should have lost special duty on that because there was no one-on-one relationship with the person in there.
Oh, interesting. Right? Interesting. Yeah.
They should have lost that case. There was a special relationship with the husband who is not the victim. The husband didn't rely to his detriment.
Well, he lost something. He lost something. So
yeah, that's how they. In any event, here
the reason I'll come back to that because there's a line of cases that kind of tie into that too. But
and listen, I had one when I worked with the court system, and this is important to mention, where neighbors were calling on behalf of a baby and saying the baby's being abused. And so social services never went to check. So they sued the state because the baby ultimately was killed. And I remember the judge and I were very distraught saying, how do we get past special duty? Because the state here screwed up. And ultimately, though, the problem is the baby didn't call, but somebody had to call on behalf of the baby.
There's a line of cases, Brad. It's totally ironic here. There's a line of cases where people have sued the fire department because the fire department didn't rescue an animal. Okay. Yeah. And the special duty kicks in when you give assurance to the person, we're going to go get your parakeet, or we're going to get your dog, or we're going to go get whatever, your pet alligator, whatever it is. They make the representation that they're going to go in. And then once the person's kind of calmed down, they don't bother going in. And they say they had a special duty because they gave them the assurance and the person might have gone in on their own. Now, there's a little bit of irony there, is that somebody can have a special duty based on their dog dying and not their child. I mean, that's a little bit, that's a little bit of a stretch there. Yeah.
And here, though, it wasn't their child. It was the neighbor, not in loco parentis, not in a parental position. But nonetheless, so these cases for the
in a wrongful death suit, you can file on behalf of the estate, so it would be. But the promise, you're right, the promise wasn't given to the child; it was given. Yeah, wow. Yeah,
so very gut wrenching because I was part of it. But 25, 30 years ago. In any event, so special duty is so important. Just because, what we want the viewers to understand is just because somebody messed up, the negligence is down in the analysis. You got to start with, was there a duty? And when it's municipal action, was it a public duty? Was it special duty, right? What's the test in your state? If they were in Washington State, it's funny, we spend so much time talking about Washington State. If they were in Washington State, the court would allow this case to go on.
Right. And Illinois too, because Illinois got rid of the public duty doctrine. And I think, folks who've been following us are going to be a little bit confused here because, and you notice that Brad and I sort of struggle with this because Brad's from New York. In New York, they don't use the term public duty rule. They just call it the special duty doctrine or special relationship or whatever. But to me, it's the flip side of the public duty doctrine, because you have the one side, if the duty that you owe is what you owe to the public, you can't sue on it unless there's some sort of a special duty or special relationship. So it's like, to me, it's the flip side of the public duty doctrine. But
yes, it is. So anyway, that we beat the heck out of that. It's a great thing for everybody to know, but everybody should know it. If you're in public service and everyone's like, oh my God, we screwed up. Wait a minute. Did you owe a duty to the person? And so it's another protection offered to municipalities.